Hi, good morning, Amanda. You have mic access. You can ask your question. Neville, we've given you access. You can go ahead and ask your question.
I heard your voice, but nothing else is happening. No slides, no talking.
Okay, Neville, we see your hand was up. We thought you had a question. We will start the presentation shortly.
Good morning, everyone. Welcome to the discussion on the different types of irregularity reports that must be lodged in terms of the Phase Act. My name is Zinhle Ngcobo. I am an analyst within the Conduct of Business Division of the FSCA. The Conduct of Business Division is responsible for supervising approximately 10,000 FSPs, and the departments responsible for these are the financial advisors and intermediaries.
Zinhle, you're on mute.
Sorry about that. I was on mute. Good morning, everyone. Welcome to the discussion on the different types of irregularity reports that must be lodged in terms of the Phase Act. My name is Zinhle Ngcobo. I am an analyst from the Conduct of Business Division of the FSCA. The Conduct of Business Division is responsible for supervising approximately 10,000 FSPs, and the departments responsible for this are the Financial Advisors and Intermediaries Department and the Investment Providers Department. The Financial Advisors and Intermediaries Department is responsible for Cat 1 and Cat 4 FSPs, and the Investment Providers Asset Managers team is responsible for Category 2s, Category 2As, Category 3s, and Category 1 investment administrators. Please take note that the Investment Providers Department also includes the collective investment schemes and the hedge funds team. As the authority, we are pleased with the positive response to the workshop, and we look forward to making this a meaningful and insightful session. The purpose of this workshop is to unpack the legislation and to unpack the legislation and the guidelines around irregularity reporting, which non-compliances are deemed as material and must be reported immediately, and which may be reported at a later stage if not resolved within reasonable time of monitoring. Today, we are very honored to be joined by a head of department, Ms. Mtebele, who will welcome you to this workshop. Over to you, Ms. Mtebele.
Thank you so much, Zinhle, for that warm welcome, and a very good morning to all the participants on the call, and a warm welcome to you all. Thank you for making time this morning to attend this session, and also a very good morning to my FSCA colleagues. I would like to first thank you, as I said, for making time to attend this session. And I really hope that it will be a fruitful and insightful engagement. So as you are ushered into the session, please make the time to engage usefully and participate so that at the end of the session, we can all get something out. Maybe just to give background into the reason why the authority decided to hold these workshops is that as the regulator number one, we rely on these reports in terms of the requirements of the FASE Act. And we have identified a need to clarify why it is important for us to receive these reports. And we also need to clarify the position in terms of the responsibilities on who needs to submit the irregularity reports to the authority. We have figured that there has been a bit of uncertainty in terms of the responsibilities of who is responsible, as I have mentioned. And I think for us as a conduct regulator, because we have now shifted into focusing on conduct, and the irregularity reports are an important aspect of us being able to identify any misconduct that could be happening into the affairs of the FSPs. So it is a great tool that we use in our supervision, and it helps us to identify information that is very valuable for us to be able to pick up any trends or emerging conduct risk or any potential harm that could be imposed on the investors. And as I have said, it is important for us to clarify the roles in terms of who is responsible for what. And that is what my colleagues today will be taking you through. So without further ado from my side, I would really just want to welcome you into the session. I have colleagues who have prepared very useful conversations and discussions around irregularity reports, and they will be taking you through the session. And please feel free to engage so that we can have a meaningful outcome out of this. Thank you very much, Zinhle.
Thank you very much, Ms. Mtebele. Thank you so much for the warm welcome and for framing the conversation of the day so impeccably. The presenters for today consist of three of our specialist analysts, Matshidiso Malgas, Thandiwe Malefo, Swarts from the Financial Advisors and Intermediaries Department, and the investment providers, the asset managers team. We are also joined by Akashen Rampersadh, who will also take us through the beneficial ownership information that is required from each FSP. I would like to take this opportunity to tackle the house rules before we proceed with the program. All the mics have been muted for the duration of the workshop. Each speaker will go through their section of the presentation, after which we will then open the floor for questions relating to the relevant section being covered. You are welcome to pose your questions relating to the slides on the chat box during each presentation, and our esteemed colleagues will respond to your questions on that forum. Questions regarding beneficial ownership will be addressed after Akashen's presentation. We will also respond to some of the questions in the chat box verbally once the floor is open for the questions and answers. Please raise your hand in the reaction section of MS Teams and your mic will be enabled for you to ask your question or to share your comments. Do note that there may be a lag in the mic enablement. Please bear with us when this happens. In the event that your mic does not work at all, please pose your question in the chat box and we will answer you. We will also afford you comfort breaks in between each speaker for you to gear up for the next speaker. If the questions that are posed relate to sections that are still upcoming, we will pause the questions and ensure that our explanations cover your questions. Please note that this workshop is for engaging the industry participants on the subject matter and is not accredited for CPD points. Before I hand over to our first speaker, I would like to run through what you can expect from today's session. So the first session will cover the applicable provisions, some key definitions, Section 19.4 Auditors Irregularity Reports and how materiality is assessed, and some insights from the IRBA Guidelines that were published in 2019 on the Section 19.4 reports that are lodged by auditors. The second session will cover Section 17 reports that are lodged by compliance officers, the irregularity guidelines, method of submission, what must be considered in the submissions, and how the irregularities are processed within the FSCA. The third session will then go into the practical application of what is deemed as material and immediately reportable irregularities. These are grouped into irregularities relating to the authorization of the FSPs, the key individuals, and the representatives. We expect that this particular session will demystify a lot of gray areas that may exist for many of us within the industry. I will now hand over to my colleague, Matshidiso Malgas. Over to you, Matshidiso.
Thank you, Zinhle, and thank you to Kwata as well for welcoming us in this workshop this morning. So the first section that I will be covering is the applicable provisions within the Act. So irregularity reports are submitted in terms of the Phase Act, and there's two instances where they are submitted. The first being Section 17.1c, the second being Section 19.4. The provisions of Section 19.4, 5 and 6 relating to an auditor of an authorized FSP providers apply with the necessary changes to a compliance officer. So Section 17.1c applies with regards to the necessary changes to a compliance officer in terms of submitting irregularity reports. So I think it is important to note that the provisions makes reference to must and not may. That is, when auditor identifies irregularity within the FSP, he must or she must submit an irregularity report, and that it is a statutory obligation to submit an irregularity report. Okay, so now we'll go through the definitions in terms of the Phase Act and the terminology that is used with regards to irregularity reports. So what is an irregularity? It's an event of non-compliance with or a breach of the Phase Act, and any event that has or has a potential to have an adverse effect on the authorization of the FSP or the clients of such providers. And what is material? Material may be defined as being of real importance or great consequence. Reportable matters are those that will have a significant adverse effect on the authorization of the FSP or the clients of such providers. And then in terms of Section 71c, the provisions of Section 19.4, 5, 6 relating to an auditor of an authorized financial service provider apply with the necessary changes to a compliance officer. So the reference to an auditor in 19.4, 5, and 6 is replaced by a compliance officer for purposes of Section 17.1c. So in this case, for example, where an compliance officer is handing over a handover report, as was previously known, and compliance officer would have, in the instances where he had identified irregularities, submitted an irregularity report. And then in terms of Section 19.4, despite anything to the contrary contained in the law, the auditor of an authorized FSP must report to and inform the authority in writing of any irregularity or suspected irregularity in the conduct or the affairs of an authorized FSP concerned, of which the auditor becomes aware in performing functions as an auditor and which, in the opinion of the auditor, is material. So the important words here is must. Sorry, Tanya, before we continue. The important words here is must, that the auditor must report, and that the report must be in writing of any irregular suspected or any irregularity that has occurred. So whether the irregularity has occurred or there's a suspected irregularity must be reported and it must be in writing. So in terms of Section 19.4 Auditors Irregularity Report Guidelines, so in terms of Section 94 of the Act, the auditor must inform the authority directly in writing of any irregularity or suspected irregularity, as I've indicated, in the conduct of the affairs of the FSP consent, with the audit, which the auditor becomes aware of in performing his function as auditor and which, in his opinion, is material. The authority requires the auditor to report Section 19 for irregularities as and when they are identified during the auditor's relationship with the FSP. So in this case, the auditor may, by notice, direct that person, the control of that person, which relates to the subject matter of such contraventions or failure, to appear before the authority at a specified time and place for the purpose of discussion such matters with the authority. Or that person might arrange for the discharge of all or any of that person's obligation in terms of this act. So if satisfied that in the case concerned, significant prejudice or damage to clients has occurred or may occur, apply to a court for an order restraining such person from continuing business or dealing with the funds or other property held by such person on behalf of clients or other persons, pending the institution by the authority of an application or action contemplated in Section 33(1) and 2, or the exercising by the authority of such legal remedy as may be available to the authority. And that if prejudice or damage may have occurred to clients, refer the matter together with any information or documentation in the authority's possession to the Ombudsman to be dealt with as a complaint by the client concerned. So in terms of Section 19.4, the guidelines that have been issued by IRBA, a report is made regardless of steps taken by management to correct the irregularity and does not allow for a 30-day period within which members of the management board are allowed to make representation in respect of the report in accordance with IRBA guidelines. So in this instance, the auditor must submit the report to the authority immediately when he becomes or suspects any irregularity taking place within the service provider's business. And this does not allow for the 30 days that the auditor would have submitted the report to IRBA. The irregularity does not need to be proven occurrence as indicated by any irregularity or suspected irregularity. Where the auditor suspects that an irregularity would have been reported, had sufficient proof been available to conclude that it was a reportable irregularity, the auditor will report that suspected irregularity and provide the authority with basis for the suspicion. In this case, it is advisable in circumstances of uncertainty to obtain legal advice. So auditors may take legal advice before deciding whether and in what form to report an irregularity to the authority. And also just to say that it is a legal duty to report directly to the authority in terms of Section 19.4 of the FSCA Act, only in respect of material matters that the auditor becomes aware of. So the Act leaves the determination of whether an irregularity is material or not up to the opinion of the auditor. So the auditor will apply professional judgment or professional skepticism. That is, they will have a questioning mind and being alert to anything that may indicate misstatement due to fraud or error within the service provider's business. So the materiality factors that are to be considered for the purposes of the presentation of the financial statements may not be relevant when determining the materiality factors for the purposes of Section 14. So materiality in the context of Section 19.4 is unlikely to exceed materiality for financial statement purposes, and in most cases will be of lesser value or may be qualitative in nature. So irregularities are not only those irregularities which are quantitative, but also qualitative irregularities must also be submitted. The underlying intention of Section 19.4 is to direct the auditor's attention to matters that cannot be tolerated in the conduct of or in the affairs of the provider acting under the FACE Act, if all the objectives are taken into consideration. The authority relies on auditors' assistance and judgment in identifying non-compliances. So matters which in particular constitute contraventions of provisions of Section 19.3 of the FACE Act and reporting requirement of Section 19.4 of the FACE Act that directly threaten the continued maintenance of the provider's business or constitute conduct contrary to the public interest in the proper exercise of the rights granted by the FACE Act. So in terms of Section 19.4 of the FACE Act, irregularities, there's some irregularities that we've identified, which may be examples that would typically be reported to the authority in terms of Section 19.4. The list is exhaustive, but these are not only the examples that are there. They can be more than any of the examples that we've identified. So one of the examples is the audit client is acting as a provider as defined in the FACE Act, but is not licensed as required by Section 7.1. So the entity may be running an unlicensed business that would qualify as a reportable irregularity. So the provider, another example is where the provider has dealt in a financial product for his own benefit, account or interest based on advanced knowledge or pending transactions for its clients, or on any non-public information, the disclosure of which would be expected to affect the prices of such products. Another example is the provider appoints key individuals, representatives to manage or oversee the business of the provider, but these individuals and representatives do not meet the fit and proper requirements. So where key individuals and representatives do not comply with the competency requirements. Another example is where the conduct contravening any provisions of the Act, the General Code of Conduct, or any other subordinate legislation will constitute an irregularity and includes matters pertaining to the provider's internal financial administration, where this appears irregular or improper in relation to the industry practice. Another example would be an irregularity may not always lead to financial loss for the provider or an outsider, but might, among others, represent a serious regulatory breach of which the authority must become aware of. One other example of an irregularity is where the provider receives commission income for product categories that is not authorized for or is not licensed to provide. The provider may have also recorded cash or unreferenced cash deposits that cannot be traced to a related transaction or service. The auditor in this case must consider money laundering and terror financing triggers when auditing bank statements. Another example was the provider maintains varying financial statements for different regulators, where a provider might submit different set of financials for the FSCA and different set of financials for other regulators. Non-compliance with financial soundness requirements. A provider is declared insolvent, provisionally insolvent, or in the process of being declared as such, and has not disclosed that to the authority. Or where a provider is placed under liquidation, provisional liquidation, or is in the process of being declared as such, and also in that case has not alerted the authority. A provider not reporting non-compliance with financial soundness early warning, that is a non-compliance, which can also be a reportable irregularity. A provider that holds, controls, or has access to client assets, or that collects, holds, or receives premiums or other monies in respect of financial products, not maintaining separate bank accounts in accordance with Section 10 of the General Code. Another irregularity is a provider under business rescue or business rescue proceedings and has not disclosed this to the authority. Thank you. So before we move on to the next section of the presentation, now we'll open the floors for questions.
Arends, we've given you access, and then we will give Ngcobo access thereafter.
Okay. Okay, I see there are a couple of hands up.
So Arends has mic access as well as Ngcobo. So please Arends first and then Ngcobo.
Okay.
Please unmute your mics. Okay, it looks as if Arends is unable to speak from his side. Ngcobo, do you want to go ahead?
Paul, are you there?
Norman, you have mic access. Please unmute and go ahead. It looks as if we have a slight problem that people aren't able to speak from their side, although we've enabled the microphones from our side. So if you don't mind just typing your question, Shlangwani, we're going to give you access as well. Shlangwani, you have mic access. You are welcome to unmute and speak.
Hi, can you hear me?
Yes, I can.
Yes,
Please go ahead.
Okay. No, it's just a question to say why are the financial FSPs invited in this meeting, because I'm thinking it should be our auditors or our compliance officers, yeah. Because I think the compliance officer is the one who will be finding out these things and then reporting me or whatever. Yeah.
So, Shlanganani, we have not restricted the access to this workshop only to FSPs or only to auditors or only to compliance officers. Remember, FSPs remain responsible for everything that happens in their FSP. They are responsible for the management and oversight of the functioning of the FSP. So even if they are not going to be reporting themselves, they still need to understand what the basis of such a report will be, as well as the consequences of reporting or not reporting. So obviously, auditors and compliance officers are also in the audience, but it is not restricted only to them. As the FSP or the key individual of an FSP, it is important for you to understand what the situation is, what are the reportable irregularities, and what would happen if you don't mitigate it or if you mitigate it. I hope that helps.
No, thanks, yeah.
Norman, do you want to try and unmute your mic from your side? We've given mic access to Norman, John, and Ngcobo in that order. We've also given mic access to Marcus. I think it's literally the case of the first person who now unmutes. Please go ahead and speak. So all you need to do is unmute your mic at the top of your screen, and then any one of the four, Norman, John, Ngcobo, or Marcus, would be able to go ahead and speak. John, it looks as if you've unmuted your mic. Please go ahead.
Hi, regarding that point 12 in terms of early warning non-compliance, early warning is not a financial, is some sort of attack on. I've had instances in the past to put early warning notifications in. That is not categorized as a transgression. There was some input, and since then I've repeated these early warnings, but there's been no response from the FSCA.
John, can I stop you there?
Yeah.
That's actually really strange, because we do take early warnings really seriously, and we have a whole process that kicks in of interaction between ourselves and the FSP, and we really become a partner in the FSP's restoring a comfortable level of solvency. So could I ask you in those instances that you can contact myself or any one of the other managers in either the financial advisors and intermediaries department or in the investment provider department, and we will definitely make sure that you get into contact with the relevant analyst on that specific situation.
Okay, the circumstances were that there was a justification in terms of the category of business, and full justification was made, which was accepted in terms of the initial report. But this is a continuing status.
Okay,
now,
then we need to normalize and manage it.
How often must one report it?
Okay, so John, this is a really good question, and I do think that we might need to take this offline as well to just talk about the specific situations. But I'm going to kickstart, and then I'm going to ask my colleagues Matshidiso and Martha and Thandi to just from their side also add anything that I'm not necessarily addressing. But with an early warning, we really have to engage the FSP and all the relevant role players in the FSP, see what the situation is, and if it is a big issue. So if it's an ongoing long-term condition that cannot be restored fairly easily, we may need to go to an exemption, but we do deal with these things on an ongoing basis and on a case-by-case basis. It's very difficult to say, yeah, this is what we're going to be doing in exactly the same situation, because one FSP situation may differ from the next one, which is why we then kickstart the process of engagement. We become very close partners in the business relationship then in that instance. But I don't know, Matshidiso, Martha, do you want to just perhaps add anything? And then thereafter, we're going to try Ngcobo and then Marcus.
No, Sharon, I think you just made exactly, good points there. There's nothing to add. We really do work on this early warnings, because remember, we don't want the FSP to actually get into the non-compliant status. So the early warning is just to say, watch out, you're getting into the non-compliance status. So it's for us to make sure that it doesn't get to the stage where the FSP is non-compliant. So it's really, we do engage with the FSPs when it gets to this stage, so that we know that they address the issues before they get to the red status, if I might say so. Thank you.
Okay, thank
Thanks,
you.
Martha. Thanks, John.
Right.
Ngcobo, do you want to try again to unmute your mic? It looks as if Ngcobo is a problem. Marcus, your mic is unmuted, so please go ahead.
Thank you for giving me this time. I am learning a lot by these workshops. And my question is, will you share this slide to me? Because I am in a highly regulated industry. I don't want to miss anything while I'm in this industry. Thank you.
Hi, John. Just to answer your question, the slides will be hosted on our website together with today's presentation on the FSCA website and on our FSCA YouTube channel. Did I answer you, John?
Yes, I'm answered.
Legacy Funerals, do you want to go ahead? And then thereafter it's the Tebogo. Legacy Funerals, just click on the microphone at the top right-hand corner of your screen and you should be able to unmute and talk. There we go. Just unmute again. You were unmuted.
Hello, can you hear me?
Yes.
Thank you. Thanks. I have one question in connection to with the previous speaker's presentation. Also to the question that was posed there's a gentleman who posed a question earlier on as well. I had a query with a certain FSP in connection to the premium that we paid to that FSP. That FSP is an administrator, so it's supposed to have been paid over to the underwriter. But that FSP owned those premiums and did not pay them over. And we've reported this to the FSCA. There is a gentleman which I've been speaking to in connection to this. This incident took place last year, and it has been dragging since now. There's an email which I've sent him a couple of times, inquiring about this, what is going on. And the gentleman from FSCA is not getting back to me with this matter. So
thank you very much. So Legacy, thank you very much for your question. Could you please put your FSP number and your email address in the chat function? And then we will follow up on this specific query and we will contact you either this afternoon or tomorrow morning at the latest.
I would really appreciate that. I would really appreciate it because
Okay.
it's been a concern.
We understand completely, but this is not the forum to assist you on an individual basis with this, but we will definitely assist you on an individual basis.
Thank you. Thanks, I'll do
It's
so.
a pleasure. Then Tebogo, you have mic access. Please go ahead.
Tebogo, please unmute your mic and then go ahead. The floor is yours. Mariska, we have given you mic access. Please unmute and go right ahead.
Good morning, everyone. Just two questions quickly. I want to just know what the impact will be of Section 19 on the crypto industry, specifically when they hold client funds. And then my second question is, what would be the best method of communicating the responsibilities of the auditors in these industries? Because some of them might be also new, with the requirements going forward.
So Mariska, thank you for the questions. The crypto industry, in terms of being regulated, is still very much in the beginning of the process. So what we will be doing is, as we have more clarity on exactly how the requirements will apply to crypto asset FSPs and their staff, we will be conducting workshops and providing guidance on this next year. So I take your question, but it's a bit premature for us to give you a clear answer at this stage. But it's certainly some of the aspects that we are working on to provide clarity.
Okay, no, that's 100%. As long as we know we're getting something, I'm happy with it. Thank you.
It's a pleasure. Good luck. I see that Martha has her hand. Please go ahead, Martha.
Yes, regarding the question on the auditors, actually the concern, it's not only about the new auditors, it's also about the, those auditors who've been in the audit space for a while. When it comes to, I also saw the comment on the chat box, when it comes to the section 19.4, in terms of auditors submitting irregularity reports, it's being a challenge for us, to be honest, because we are not getting these reports to the extent that we would like to, and we get very few of them. So it's our intention to engage more with the regulator IRBA, and then in a coincidence, there was actually a letter from IRBA asking us what recommendation we can make, and one of the highlights we made to them is that they make their auditors aware of the reporting requirements in terms of phase to report the Section 19.4 irregularity report to us, because they're really not forthcoming to the authority. So it's not only regarding the new auditors, but the audit space as a whole. And one thing I would that we ask the Compliance Institute of South Africa to engage the auditors of the FSP that they deal with, that they also, communicate with the auditors together, that any issues that they pick up to also report from that side of the auditors. So there must also be that working relations between the compliance officer of the FSP and the auditors of the FSP when they're doing the monitoring. Thank you.
Thank you, Martha. That's very useful. Do you want a break? We've come to the end of the first section on the Section 19.4 irregularity reporting, and we don't have any. I see we've just received a hand. Let me just check whose hand it is. Okay, Sam, we're going to give you mic access. Sam, please go ahead. And then after Sam, we're going to take a 5-minute leg stretch, and then we will kick in with the next section on 17.4s.
Okay. Thank you for the opportunity and good morning again. I just have a concern, man, that if we are being regulated, I understand it's very, very important that you get regulated. But then I don't see any issues being raised about people who are doing our job without being licensed. You see them at the malls, you see them at the corners of the streets in town here, having application forms from with t-shirt also from different companies. But when you ask them about anything that has to do with FSCA, licensing and whatever, they know nothing about it. You find them also inside the pick and pays, selling funeral policies and all that. I just want to find out what is the FSCA doing about that? Because again, these people are actually stepping on our toes because they are doing what we are supposed to do at FSPs, but they don't even pay any licenses. Some of them even have offices also in town here doing the same job that we're doing. But I don't see any action being taken against that or discouraging that. And so our job is our own profession that is actually being treated with less respect by anybody who wants to sell policy. Just want to get assistance on that. At the end of the day, we are the ones who must be regulated, but a lot of people are doing our job without any regulation. Thank you.
Sam, thank you very much for your question. As the authority, we work on an open door policy. As you are an FSP, it is also your responsibility to use our complaints department for you to lodge complaints, and then we will look into it. Because as the regulator, I mean, when we work with FSPs that are regulated, we also do take into cognizance that there are people who are not regulated. And if you complain and then you tell us where these people are operating, we will take action against them. Because sometimes when we get complaints, we do follow up and then we do take action. So if maybe you can just complain on our website and then tell us where these people are operating, we will take action against them. Does that help you, Sam?
Thank you. I think it will help a lot because apart from helping us, it also ensure that our job gets respected by the community.
Yes, so that is why it's important for us to work together. So as regulated FSPs, it is very important for us to work with you guys. You work with the authority, we work with you guys for us to protect and professionalize the industry. I see that Matlo has her hand up. Matlo, over to you.
Hello. Can you hear me?
We can
Yes,
hear you,
Matlo.
Malgas.
Oh, thank you. Yes, I just wanted to add to that when people complain, it's important to actually submit some kind of evidence, because it's one thing to just allege or to just say someone is standing at the corner of whatever street selling policies. How will you support that kind of allegation? But when someone says to you, these people gave me a brochure or they gave me this and that, or you can see a business card of sorts, and these people have their contact details there is somehow an ability for us to actually contact these people, then that is 100%. So when you get these people or when you see these people, try to gather as much information, especially the documents that they may have, the documents that they use to lure people into this unregulated policies or unregulated products that they sell. So for us, it's not just about informing the FSCA, because it's different departments dealing with different issues. So gather as much information. When you send that email to us, attach as much as you have. Thank you so very much.
Thank you very much, Matlo. That really helped us. I see that Norman has his hand up. Norman, you can unmute yourself and the floor is yours.
Good morning. Thank you very much. I'm sorry I started a bit late this morning because there are so many other...
Norman, you are speaking very softly. We can barely hear you.
Okay, is that better? Can you hear me now?
Norman, we are struggling to hear you. Norman, I think we've completely lost you. can you maybe try to restart and then maybe rejoin the meeting, and then we will give you the floor as soon as we are back from the break. Or you can just type your question on the chat box. And then Tebukho, the floor is yours. Norman, we will give you an opportunity to ask your question. It's just that we are really struggling to hear you. Tebukho, over to you. Tebukho, your mic is on mute. We have given you a mic access. Please unmute from your end and take the floor.
Okay.
Tebukho, you are on mute.
Am I audible now?
Yes, thank you very much.
All right, thank you for this opportunity. Just following up on what the previous speaker has indicated, we see this trend mainly in the funeral parlor space, where mostly they operate and they sell policies without licenses. So I wanted to find out from you, what are you as the FSCA doing? Do you know maybe the percentage of those that operate with license, or those that does not have licenses? Yeah, that will be my question. Thank you.
Thank you very much, Tebukho. As Matlo has mentioned, I mean, it is very difficult for us to give you a percentage, because we as the regulator, we are not even aware that maybe 100 or 1,000 people are operating without a license. So that is why we are asking you, we are really pleading with you as the industry, that if you notice that someone is operating without a license, I mean, doing business without authorization, you gather much information, and then you send us that complaint, and then we will take action. I mean, we do get complaints. Sometimes we even, when we have our engagements with the FSPs, I mean, if you give us information that this business is not registered, but then they are doing business, I mean, we do take action, but then we don't say that we got information from Mr. Tefo. We take that very seriously, and we do protect your information and your identity. Does that help you, Tebukho?
Yeah, no, it does help. Thank you.
Okay. I see there's a Jenali. We have given you mic access, and you are the last person to ask the question, and then we'll take a comfort break, and then we will start with our second session. Over to you.
Can you hear me?
Yes, we can.
Just to add on to the last two speakers, as much as there is an obligation, this is just a comment, as much as there is an obligation on us to inform the FSCA via the complaints line, I do think that a more proactive approach should also be taken by the FSCA. I mean, if these guys are operating at public places like your grocery outlets, etc., surely a more proactive approach can be taken instead of just relying on the public or the FSPs to inform the FSCA, of these funeral non-licensed FSPs that are selling these products. Because if it's at a Pick n Pay or a Checkers, it's really not. It's not hidden, it's out in public. So the same way you do, for example, mystery shopping, I think as much as there's an obligation on us to inform the FSCA by the complaints line, that a more proactive approach should also be taken by the regulator to seek out these unauthorized FSPs.
Thank you very much for that comment. It is really appreciated, and we will take it upon ourselves to be proactive. Thank you very much. We will now take a 15 minutes comfort break. We will be back at 10:15. Thank you very much. Welcome back to the session. I hope you are all refreshed for the next presentation. I will now hand over to Thandiwe